Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, the Supreme Court heard oral argument in the Munoz case, the case about the doctrine of consular non-reviewability out of the Ninth Circuit, discussed on episode 128. The American Bar Association Commission on Immigration, on which I serve, submitted an amicus brief in that case, with the big help of Sidley Austin, for which we are very grateful. Commission Director Meredith Linsky attended oral argument and reports that Ms. Munoz's counsel did a terrific job. He's one of our own. Congratulations to Eric Lee on your Supreme Court oral argument. Go get some much-deserved rest. If you're interested in joining or supporting the ABA Commission on Immigration, or their very important projects like the IJP in San Diego or ProBar in Harlingen, Texas, shoot Meredith or I an email, or give it all a Google. The Commission can always use volunteers or staff attorneys or administrative staff to help fulfill the important work it does. Not only that, but the Supreme Court justices also heard oral argument this week in the perfectly named case Trump v. United States, discussing how much crime, if any, a former president, like the former president, can commit without fear of prosecution. 3 cases again this week, published by the same 3 circuits as last week, if anyone cares. Here they are. Our first case is Queen v. United States, published by the 5th Circuit on April 24th, 2024. This case caught my fancy this week. Watch out, world. Because it's about the Federal Tort Claims Act, and well, it's a positive case for those who would bring such claims. The FTCA is one of the only ways for a non-citizen, or anyone else for that matter, to ever sue the United States government. So why not do the decision, right? Mr. Queen is a federal prisoner, similar to, say, a non-citizen in immigration detention. In January 2019, Mr. Queen was napping in his cell when he was awoken by 4 prison officers. Quote, unsure of Mr. Queen's condition, one of the officers instructed Mr. Queen to stand. When he stood, he grabbed one of the officer's right arms and said that he needed a moment to breathe. End quote. That did not go over well, it seems. Mr. Queen, quote, alleges that the officers, unprovoked, hit him in the face, pushed his head into the wall, choked him, jumped on his back and legs, smashed and twisted his arms to apply restraints, pulled his pants down, and dragged him to the on-site medical clinic. End quote. The officers allege that Mr. Queen started it all by pushing an officer and then lunging for another. Regardless of who started it and what happened, Mr. Queen complained of shoulder pain to the nurse. The nurse, quote, noted slurred speech, nonsensical answers, and dilated pupils, and concluded that Mr. Queen was most likely under the influence of an unknown substance, end quote. It appears he was not, but unsure. and over the next few months he kept complaining about his back, shoulders, hip, and knee pain, but to no avail. Once released from prison, a doctor diagnosed Mr. Queen with injuries that were so severe that he couldn't work. Back to the time he was in prison, though, Mr. Queen sued the United States for the assault under the Federal Tort Claims Act, or FTCA, for physical injuries arising from that January 2019 incident. Pro se by himself, no less. A federal magistrate judge, however, and a decision affirmed by a federal district court judge, granted the United States motion for summary judgment and dismissed the whole case at the summary judgment stage. Which is actually a bit odd if a case is going to get dismissed. It usually happens at the motion to dismiss stage, but whatever. Sometimes this happens. Quote, the magistrate judge concluded that Mr. Queen's injuries were de minimis and therefore insufficient to support an FTCA assault claim against a prison officer, end quote. Mr. Queen took that ruling to the Fifth Circuit by himself, and he won. Like for all motions for summary judgment, or for that matter motions to dismiss, the alleged facts are viewed in the light most favorable to the non-movement, here, Mr. Queen. That means that we're assuming his version of what happened and his version of the injuries. Now apparently for such cases, prisoners must show physical injury to support mental or emotional claims to FTCA relief. Not only that, but the Fifth Circuit, where lots of immigration prisons are too, there is a requirement that prisoner injuries, quote, be greater than de minimis, end quote. But as it turns out, that rule, that de minimis threshold requirement, is only for constitutional claims, prisoner claims based on violations of their constitutional rights, for example. It does not apply, explained the Fifth Circuit, to FTCA actions because FTCA claims are civil. As with all FTCA injury claims, I believe, the relevant law and the relevant threshold requirements are based in tort law from the state in question. Here, Louisiana. Quite a few immigration detention centers in Louisiana, end quote. Louisiana law does not impose a de minimis injury bar to tort claims, end quote. That means that the magistrate and district court federal judges were wrong to dismiss Mr. Queen's civil FTCA action. Which means that it's going back, either for further summary judgment analysis or even a trial. Good case to remember, immigration friends, if you think you have claims to sue the U.S. government under the FTCA for harm that occurs to your client in an immigration detention center in Louisiana. And that is Queen v. United States. Next is Ndlovu v. Garland, published by the Seventh Circuit on April 25th, 2024. It's a short one from the Seventh Circuit. Mr. Ndlovu is from South Africa, has been in the United States for a long time, and has U.S. citizen family members. While the decision is quite short on details, the immigration judge found him statutorily eligible for non-LPR cancellation of removal, which I suppose means that the immigration judge also believed that his removal would cause exceptional and extremely unusual hardship to his U.S. citizen or lawful permanent resident family member? No small preliminary holding. Nevertheless, the IJ believed that Mr. Ndlovu didn't warrant the relief as a matter of discretion. Quote, the IJ observed that Mr. Ndlovu had twice pled guilty to operating a vehicle while intoxicated in 2000 and 2010, and had recently been arrested for driving under the influence in 2018. The IJ also noted that Mr. Ndlovu pled guilty to domestic battery in 2002, and was again arrested for domestic battery in 2009, though those charges were dismissed. End quote. Weighing all that against the positives in Mr. Ndlovu's life, the IJ said that the balance warranted denial. The BIA affirmed, and Mr. Ndlovu petitioned for review, arguing that the IJ erred in considering the 2000 and 2002 convictions because they were so old and were outside the 10-year good moral character period required for non-LPR cancellation of removal. But to me, and as this decision is written, the IJ denied on discretion. And that's pretty much exactly what INA Section 242A2BI would bar review of after Patel, which is what the Seventh Circuit essentially held. To survive review, Mr. Ndlovu must bring a colorable question of law or constitutional law under INA Section 242A2D. That includes mixed questions of law and fact, as explained recently in Wilkinson v. Garland. But, quote, to be colorable, the legal question must have some possible validity, end quote. And I guess technically Mr. Ndlovu actually did bring a question of law. He argued that the 10-year period whereby a non-citizen must establish good moral character for non-LPR cancellation of removal applies to the discretionary determination as well, and that thus, quote, the IJ and BIA committed legal error by considering conduct outside this period, end quote. The problem is, said the Seventh Circuit, is that this is not a colorable legal claim. There is no legal support for the, quote, argument that there is a time limit on what conduct the IJ or BIA could consider in making their discretionary determinations, end quote. Yes, the good moral character period is limited to the 10 years preceding the application, but discretion is forever, reason of the Seventh Circuit. And well, keep in mind that pretty much all relief under immigration law is discretionary. Immigration never forgets. Without a real question of law before it, the Seventh Circuit saw this as a challenge to how the IJ and the BIA exercised their discretion and weighed the good and the bad, which Patel and the jurisdiction stripping provisions of the INA totally well strip. As the Seventh Circuit said it could not review, Mr. Ndlovu lost his case. And that is Ndlovu v. Garland. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB-5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. And so, we conclude with Rangel-Fuentes v. Garland, published by the 10th Circuit on April 23, 2024. This case is about qualifying relatives, non-LPR cancellation of removal, and asylum. Ms. Rangel is from Mexico and most recently entered the United States in 1995 or 1996 without inspection or admission. She's been here ever since. She's married and has 3 U.S. citizen children. Her youngest, Fernando, was born in September 1997. That makes him 26 years old today, but not back then. And really just highlighting the arbitrariness of life, DHS initiated removal proceedings in 2012, quote, after state law enforcement arrested her for contempt of court following her failure to appear when a gym sued her over unpaid membership dues, end quote. That's definitely a new contender for most trivial way to begin what could result in permanent exile from this country. The podcast is accepting your competing examples, though, counsels. When it became time in removal proceedings in 2014, Ms. Rangel applied for non-LPR cancellation of removal, arguing that her removal would cause exceptional and extremely unusual hardship to her only qualifying relative that she still had, Fernando, who at the time was 17 years old. And at the time he suffered from depression and possible thoughts of suicide. Children stop being qualifying relatives for non-LPR cancellation of removal purposes when they turn 21. And that is if they remain unmarried, by the way. Ms. Rangel later applied for asylum and related relief based on recent violence against her family in Mexico. In what seems like a bit of a favorable thing to do for Ms. Rangel, quote, the immigration judge declared the record closed in September 2017 when Fernando was 20 years old and thus a child for purposes of cancellation of removal, end quote. I guess that was following a merits hearing? Unclear whether or not the IJ intended to grant non-LPR cancellation, but it seems like the IJ might have. But if that was the case, the IJ couldn't officially grant non-LPR cancellation because Congress saw fit to limit EOIR's ability to grant this sometimes only available form of relief to 4,000 grants a year, which has long been over the limit, meaning that grants are now backlogged in the immigration courts by 2 years or more, sometimes even 4 years. By the time a number became available here, Fernando had aged out, and so the immigration judge denied relief. The IJ also denied asylum, reasoning that Ms. Rangel waited too long to apply and that in any event hadn't established a well-founded fear on account of her membership in a viable particular social group. The BIA affirmed. The 10th Circuit sent it back in part by split decision. Not for nothing, the 10th Circuit held that it didn't lack jurisdiction to determine whether Fernando had aged out, notwithstanding Patel. It was a legal question, or at least it's a mixed question of law and fact that Section 242A2D permits review of, thank you, Wilkinson. But this whole thing is a rock-and-a-hard-place situation of Congress's own intentional and arbitrary making. Congress has defined what a child is for immigration purposes, and Congress has capped the amount of non-LPR cancellation of removal grants that can occur in a given year, creating this backlog. A cap that has not changed even as the immigration judge bench has expanded significantly. If EOIR eventually gets to 1,000 IJs on the bench, which seems like what's happening, that's 4 cancellation of removal grants per IJ a year. Obviously, it's a bit more complicated than that, but I don't know, Congress, if we're going to keep the cap, maybe tether it to inflation or interest rates? Seems only fair. But it's a statutory cap, so there's really no way around it. Ms. Rangel's argument is that Fernando's age should have froze when the IJ closed the record, and Fernando was still under 21 years old. Not sure how that whole argument about freezing a qualifying relative's age would go in another circuit, But it's very interesting here given the 10th Circuit's decision in Martinez-Perez v. Barr, discussed on episode 26. In that case, the 10th Circuit held the age-out period under the statute ambiguous. Can a child's age freeze for non-LPR cancellation of removal purposes at all? If I'm not mistaken, Martinez-Perez reasoned that if nothing else, the age might be able to be clawed back for a qualifying relative who ages out if the delay that caused the age-out is the fault of EOIR. To the 10th Circuit panel here, though, the BIA below in Martinez-Perez hadn't discussed the issue at all about freezing. Here, in contrast, the BIA explained below that non-LPR cancellation of removal, like all applications for relief I assume, are continuing applications, meaning the age of the qualifying relative at the time of adjudication is what governs, regardless of whether the IJ closes the record or not. Under that theory, Fernando aged out, albeit due solely to Congress's cap on the amount of grants that can occur for non-LPR cancellation of removal purposes. Having already deemed this age-out statute ambiguous in Martinez-Perez, the 10th Circuit believes here that we're already in Chevron deference territory, at least for the next 2 months. That means that the BIA's reasoning stands if the 10th Circuit believes it was reasonable. The 10th Circuit so believed. Now, very smart counsel made a very smart argument. The non-LPR cancellation of removal statute requires a showing that the non-citizen, quote, establish, end quote, that hardship will result absent a grant, meaning to Ms. Rangel and her counsel that the statute envisions a temporal time limit for the analysis, the quote, time at or before the closing of the record because it places an evidentiary onus on the applicant, not the court, end quote. Smart argument and the best circuit to make it, given Martinez-Perez. And maybe so, reasoned the 10th Circuit. But that reading isn't compelled by the statute, which is what the court believes is needed to overturn the BIA when we're in Chevron territory. But why not wait until the Supreme Court decides Loper-Bright 10th Circuit? At this point, Chevron deference might be dead before the court even issues a mandate in this case. I'm sure they have their reasons. And of course, Chevron might just survive this term at the Supreme Court. Who knows? Plus, explained the 10th Circuit, in matter of Isidro Zamorano, from 2012, the BIA did indeed hold that non-LPR cancellation of removal applications are continuing applications. But again, quote, that is not to say that Ms. Rangel's interpretation is itself impermissible or unreasonable, end quote. Just not good enough to overcome Chevron. To the extent that Martinez-Perez permits IJs in the 10th Circuit to freeze a qualifying relative's age under appropriate circumstances, it does not require it, explained the panel. To me, though, freezing the age of a qualifying relative still seems possible, as the BIA has never said IJs can't do it in a precedential decision, and in any event, that is not what the 10th Circuit is deferring to here. Seems like you may have a case at freezing a qualifying relative's age in the 10th if there is a serious IJ or other EOIR delay that causes the age out. But under these facts, the exceptional circumstance of the 4,000 grant cap for non-LPR cancellation won't cut it. And I mean, that's a Congress-created delay anyway. So Ms. Rangel cannot get non-LPR cancellation of removal. But 2 of the 3 judges believe that this case should be sent back for further asylum analysis. The immigration judge denied asylum and withholding of removal for a few reasons, but nexus was definitely one of them. To the 10th Circuit majority here, in denying asylum, quote, the IJ failed to mention Ms. Rangel's strongest evidence that she would in fact face persecution on the basis of the murder of her cousin, and as a woman repatriated to Mexico from the United States. And critically, this is evidence that goes both to Ms. Rangel's asserted social group and the nexus between that social group and feared persecution, end quote. This failure to consider this argument and evidence is very important here because the BIA refused to even consider nexus when it was appealed, believing that Ms. Rangel had waived the argument on her appeal to the BIA. Not so, said the 10th Circuit majority. She mentioned some of this in her notice of appeal to the BIA, and the threshold of putting the BIA on notice of an intended argument in a notice of appeal is low, explained the court. Her reference to the murder of her cousin and the fact that she was a woman repatriated to Mexico, along with some other arguments, it appears was sufficient to put the BIA on notice that a nexus and particular social group appeal argument was being made, and so the BIA was wrong to rule that Ms. Rangel had waived the argument. Judge Hart's impartial dissent would not send it back for further asylum or withholding of removal analysis. But it's a partial remand nonetheless, which means congratulations are in order for Brian Lipschutz of Paul Weiss, as well as Kenan Shan Mungum and Jennifer Kirkoran of that same firm, and Sandra Saltrice Miller of the Saltrice Law Firm. Probably not the win that Paul Weiss came on board at the petition for review stage to get, but Ms. Rangel gets another shot at something. And before we go, it's all got me thinking. Reviewing this case, an interesting argument came to my brain, assuming that Chevron is overturned in Loper-Bright this term. If non-LPR cancellation of removal is indeed a continuing application, that would mean that the qualifying relative clock continues to tick during a BIA appeal, and even on remand, assuming the BIA finds immigration judge error, right? With non-detained BIA appeals taking, 3 years? And then a remanded merits hearing being set 3 to 5 years out, refusal to freeze a qualifying relative's age arguably effectively takes away a non-citizen's right to appeal an administrative decision. That right is based in due process and constitutional principles and the interplay between the administrative state and federal courts, I believe. Taken to an extreme, a rule that didn't freeze the qualifying relative's age could result in an immigration judge denying non-LPR cancellation of removal based on clearly improper reasons like, say, race or other clear bias, even with a qualifying relative child with, say, severe disabilities. But if that qualifying relative child was 19 or 20 years old at the time that the IJ denied on clearly improper grounds, the IJ's decision would still effectively be insulated from appellate and federal court review. And that just doesn't seem right? Seems like an interesting argument for another day if Chevron becomes no more. To me, at least. And that is Rangel-Fuentes v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.